Good afternoon and welcome to the Law&Crime Report. We start off with the story of Breonna Taylor. There's a few updates in that case. The first stems from a plea deal that her ex-boyfriend, not Kenneth Walker, her boyfriend at the time in which she was killed, but instead her ex-boyfriend, the man they were looking for and found at a different location, he was offered a plea deal with an interesting twist. Let's start by looking at that clip as more information.
Bed.
Watching the movie.
So he was in your room
We was
watching.
in both of the rooms. She had actually just dozed off, probably like 10 minutes before. So laying there, laying on her, watching the movie by myself. It was a loud bang at the door. Both of us are not decent. Can't even think of the word right now. You know, we're at home. We're in the bed. It's 12 at night. Our day is over. So it's a loud bang at the door. She pops up out of her sleep. It scared her to death. Me too. Like, who is that? I was honestly thinking it was because we've been on and off together, whatever, for like 7 years or whatever. So it was a guy that she was messing with or whatever throughout that time, you know. And he popped up over there once before while I was there like a couple months ago. So that's what I thought was going on. So it's a loud boom at the door. First thing she said was, "Who is it?" No response. So we like, what the heck? We both get up, start putting on clothes. Another knock at the door. She's like, "Who is it?" Loud at the top of her lungs. No response. So I'm like, what the heck? So then I grab my gun, which is legal, like I'm licensed to carry everything. I've never even fired my gun outside of a range. I'm scared to death. So she says, there's another knock at the door. She's yelling at the top of her lungs, and I am too at this point. Who is it? No answer, no response, no anything. So we like, what the heck? We both just see what I have on. Grab the nearest thing. These aren't even mine. These are hers. Like, so we both are just putting on something to go answer the door and see who's knocking at the door. It's late at night. So when we come out, when we get out of the bed or whatever, like walking towards the door, the door comes like off the hinges. So I just let off one shot. Like I still can't see who it is or anything. So now the door's like flying open. I let off one shot, and then all of a sudden there's a whole lot of shots, and like we both just dropped to the ground, and the gun like fell like right over there, and I like kicked it because I'm like scared to death. Like now we're seeing lights and stuff, so it's looking like okay, it's the police, and there's a lot of yelling and stuff. So there's just shooting, like we're both on the ground, and then when all the shots stop, I'm like panicking. She's right there on the ground, like bleeding, and yeah.
All right, so there you can see that's Kenneth Walker's statement that was given to the officers about what happened at that event. Let's bring in my two guests. We've got Hunter Shkolnik as well as Judge Birmingham. Your Honor, let's start with you. This is Kenneth Walker reliving that event that led to the death of Breonna Taylor, his girlfriend at the time. And he, interestingly enough, is filing a suit against both the police department and the prosecution because he's alleging, among other things, malicious prosecution as well as a wrongful arrest. And he's citing the stand your ground laws from the state there, which kind of makes sense to some degree. Talk to us about that stand your law argument that he's making, that he's saying someone broke into his home and he thought that he had the right to defend himself.
You have an absolute right to defend yourself against somebody who is breaking into your house. That's what the stand your ground law basically means. And if you're in your house, especially at nighttime, and somebody's breaking in, you don't have to retreat. You don't have to seek reasonable alternative measures. That's basically what the stand your ground law means. We have that here in Texas, and they have it obviously there too. And if that happens, you can use that as a justification for your conduct so that you are not able to be prosecuted for it.
Now, Hunter, it's an interesting play for us here because in one aspect, it's the police officers executing a search warrant. I know, factually speaking, there were some issues that they said that they believed they had went to the post office and they said that suspicious packages were getting there. The post office said no one came to them. My favorite part of his motion is this, quote, "It is the tradition that a Kentuckian never runs. He does not have to." And so they're really arguing here in the suit, he's in his home and he has a right to defend himself, and he believed he was being attacked. What are some of your thoughts as to that argument?
I think what you have to understand is Kentucky is what we call a castle doctrine state, meaning your home is your castle. You don't have to run. You can stand your ground. You can defend your home. You can defend your family and your loved ones. Here, the dispute and what they're trying to say is they advised or they called out it's the police and a warrant. That's a factual dispute, which I think probably doesn't hold much water. Here, there was someone breaking into a door late at night. Mr. Walker had a registered gun. He had the right to protect him and Breonna. He had a right to shoot. He didn't have to stop. He didn't have to back down. That's the stand your ground law, and that's what he did. And then they arrest him for that, for exercising his right. This whole arrest, it really leads to this malicious prosecution. He did nothing wrong under the law. It was the police in this setting that did something wrong.
Yeah. Now, in the Breonna Taylor case, or saga, because of how long it's going on, there's another aspect that's really changing. We learned recently that the ex-boyfriend, not Kenneth Walker, but the ex-boyfriend who was the original target, he was offered a plea deal. Now, both of you as attorneys and judge, we see plea deals all the time. The interesting aspect of this was part of the plea deal, which could have avoided jail time, was to say that Breonna Taylor was a part of a drug trafficking enterprise. I haven't read any facts that support that other than trying to get a plea. Judge Birmingham, you've seen pleas before. You've taken pleas for hundreds, if not thousands, of defendants. What did you make of this plea negotiation and this concept?
Well, I want to go back to when I used to be a prosecutor. And, you know, yes, there are times and occasions when you offer plea bargains and you're hopeful that somebody will testify against somebody else. But ultimately, at the end of the day, the public is going to hold you accountable for that. And on the one hand, you're saying, we're going to give you a 10-year sentence because we think you're so dangerous you belong in prison. But on the other hand, we're willing to say you get probation if you testify against and say that she was a part of this conspiracy. Now, I don't know what the evidence is, but the public doesn't like that. And as a prosecutor, you better own your plea bargain offers when you make a plea bargain offer like that will allow somebody to go free unless they basically say what you want them to say. And there's going to be a lot of questions to be answered for that. And I will note, too, he rejected that plea bargain. Yeah. He said that he would rather stand on his ground, stand with the truth in his mind, his truth, which is she wasn't, as opposed to getting out and getting probation, which he could have had, apparently.
Yeah, that's a pretty honorable thing, I would say, in general. I know they say there's no honor amongst thieves, but that seemed pretty a strong stance to take. Hunter, the thing that really perplexed me, oftentimes these deals are given in the inverse. And what I mean by that, it's typically given to catch the big fish. You often see, for example, if Breonna Taylor was arrested and she was a small fish, to take a plea to say that the bigger fish was a part of it, it seemed almost backwards in that sense, because you'd want to go after the main person rather than this trickle-down plea offer to get someone who's already deceased. It seems really peculiar in that sense. What were your thoughts?
Yeah, you have to think about who was the big fish here. The big fish in this situation was defending the action of the police and the prosecutor here. They're doing, and I hope this is not what really occurred. It looks like they're trying to utilize the plea process to get this defendant to say something that is not true in order to get themselves off the hook. That's not what the plea process is for. It's to advance justice and do what's right. Here they were using it to do something that was completely wrong. You don't try to get someone who's facing 10 years to say someone is involved in a crime just to make it look good for the arrest and the prosecution.
Yeah. And Judge Birmingham, you brought up a good point about the prosecutor needing to back it up. In my mind, this information as to whether or not Breonna Taylor was a part of this criminal enterprise, that seems to me information that should come out from a different source. Because as a defense attorney, if we're going down this route, and let's say this gentleman takes the plea, and now I'm saying to myself, so the only information you have that Breonna Taylor was a part of this criminal enterprise is from her ex-boyfriend who said it, and there's not much else, that seems pretty weak. I'm not sure if a jury would buy that. if he did end up saying that. Like I'm creating that hypothetical. I don't know how strong that would be if that did actually happen.
Well, if it only came from him in Texas and in most states, and I'm pretty sure Kentucky's the same way, you cannot just simply take the word of a co-conspirator. There has to be some independent corroborating evidence to support it. But the peculiar thing about this is she's gone. There is going to be no prosecution. What is he going to testify to against Breonna Taylor? There's no case. There can be no case. You can't prosecute the dead. So this is a very peculiar situation indeed.
Yeah. Now, it would be very peculiar if he had done it, but on multiple occasions, Hunter, we're hearing in jailhouse calls, we're hearing in interviews that Glover, the ex-boyfriend, has given. And on multiple occasions, I think the only connection that we've really seen is that maybe he had mail delivered there. There's no real connection that we've seen as of yet to say that she was anywhere connected with this enterprise. So again, it seems like you're saying the big fish is the police department. They're trying to, I don't know, it seems like something straight out of a conspiracy theory, but all the pieces are there. What are your thoughts?
Yeah, it's very simple, and the judge hit it right on the head. The reason why you would want this defendant to take a plea and blame Breonna is if she was alive, she was here to be prosecuted for a crime. You don't do this for any other reason. It doesn't help them. It's clear the only reason why they wanted this defendant to say that she was involved was to help defend their actions here. She was not involved. There is no evidence to support that. And she's not even here to be charged with a crime. It makes no sense.
Yeah, it makes no sense unless you're doing exactly what you were saying. And it's improper if that's what's going on, because as a prosecutor, they should not be trying to find information to help a potential defendant in that way, shape, or form to get that type of information from another defendant if they've already unequivocally said that Breonna Taylor was not involved in any criminal enterprise involving drug trafficking. It's very improper if there is no facts to support that, which we have not seen as of yet. We're going to continue with more here at the Law and Crime Report right after this break.
There's still an outstanding issue, and it's solitary confinement, also known as punitive segregation. Look, we ended it already for young people, and New York City led the way in this nation in addressing the fact that we should not have young people in solitary confinement. We all remember the tragedy of Khalif Browder, and we acted on the lesson of that tragedy. He did not die in vain. But then we saw another tragedy recently, Layleen Polanco. Layleen Polanco should not have been in Rikers to begin with. Layleen Polanco should not have been in solitary confinement. And Lord knows she deserves justice. Her family deserves justice. The transgender community deserves justice. We have to right the wrong. We can't bring her back, but we can make change so that no one else goes through such a tragedy. There has been accountability. 17 correctional officers have been disciplined, 4 suspended without pay, and this is just the start of the disciplinary process.
So the story of Layleen Polanco, a transgender woman who was incarcerated for a low-level misdemeanor, is very, I would say, new, but as we heard there in that clip, it's something that we've seen in New York before. And it's something that's near and dear to my heart, especially as a public defender here in Brooklyn. Because at first you hear this story and you see error upon error. Even in the report that was filed looking at the Correctional Health Services, or CHS, and the Department of Corrections, the DOC, there were just, again, error upon error upon error. Now, I know many people rail against the new bail reform laws, but even with those laws in place, remember, that said that most misdemeanors and nonviolent crimes will not have bail. Polanco was there on a misdemeanor charge, a crime that now you cannot be incarcerated for. And she was incarcerated on what many would call a nuisance bail, that being a level of bail that is so low that if you had the money, you would pay it and be released. Something like $500 would be considered nuisance bail. Anyone would pay that. The only reason why you cannot pay that is because you are so impoverished that you cannot, and bail should not be that detrimental to someone. However, now you get the story of how this all occurred. Now, based on the report, it showed error upon error, not only in the following of strict guidelines and policies. For example, she was not put in general population because transgender women, while they may be put in female facilities, they will often put in punitive segregation or in isolation, as the mayor just said there. She was put in that environment, and when you're supposed to be checked on every 15 minutes, that's their policy, that's what they wrote in. Instead, she was checked on every 41, 37, and 35 minutes. On top of that, she came from Bellevue. Bellevue in New York is a place where people go for medical services when they're incarcerated, and then they're brought back to the different facilities in Rikers. It appears that when she went to Bellevue and then came back to Rikers, those medical paperwork, so those medical information, did not seem to follow her in a way that when she was at Rikers, those at Rikers were aware of the conditions that she had and therefore could have addressed them in a way that were meaningful, and she would not have been harmed or eventually died as she did. In the report, it shows error upon error. There was a structure in place that should have been followed, that must have been followed, and it wasn't, and it caused the death of an individual that the state has a duty to take care of and ensure it doesn't die under their watch. Let's bring in our guests. Let's start off with you, Judge Brandon Birmingham. This is a story that even when you look at the report and the key findings, you just see that no one was following the book here. It seemed like the book was thrown out from day one and it led to someone's death, and now the city is paying $5.9 million because of it. What are your thoughts?
Well, I want to start, first of all, with the beginning. And to me, this all starts with having an open and honest, non-emotional discussion about bail reform. I know that for $500, she could have been out. And if she was in Texas, it would have been $50, okay, to pay a bail bondsman. You get 10%. $50 would have gotten her out. The reason why she didn't, is it because she was dangerous? No. Is it because she posed a threat to society? Well, no, because all it took was $50 to get out. If you had a dangerous person who did pose a threat to society, who had $50, they would have been out. So the idea that, this whole thing started with bail reform laws, or bail laws, that we really need to reconsider in this country. And I understand that they have in New York, and we're working on it here in Texas, but this case shows how the system failed her. And now it's an expensive $50 bail that's costing the city of New York $5.9 million. We've got to change this and fix this.
Yeah. And Hunter, I can't go too far into the details, but from my understanding, the assault charge, and let me be very specific, it's assault in the third degree. It would be the equivalent, Hunter, of me punching you in the arm and leaving no lasting bruises or serious physical injury. Maybe a slight cut to the lip or some serious physical pain, but that's the level of assault we're talking about. We're not talking black eye or broken jaw. From my understanding, it stemmed from her being a sex worker, and what that typically means, I don't know all the facts, is it could possibly be that she assaulted a John, and there could have been a potential self-defense issue. There's also the aspect of sex workers there, where it's a vulnerable community in many ways, and yet she's in jail for $500, can't get out, and then we see what happens to her. What are your thoughts? Hunter. Okay. Hunter, I believe we're gonna come back to you in a second. That little extra caveat, Judge, does that change anything for you? Because I know in some states, and I will commend Brooklyn as being one of the leaders in that I've seen at least, there's a new view on how we view sex workers. It's not as black and white as it used to be, I would say, 30, 40 years ago. What are some of your thoughts on how we've kind of changed our view of sex workers in this country? Well,
the vast majority of those that are trafficked are victims. I mean, they are being victimized. They are being traded. They're being traded like property. And I think what I read somewhere about her case, and there's others like it, is that she was being part of a court, a specialized docket to help treat some of these folks, to try to address some of the underlying issues. Why are you engaged in that type of conduct? What is the root causes, and can you ferret out what those root causes are? And that's what I think that they were trying to do, and that's a good thing. These sex trafficked victims like that are indeed victims, and they need to be treated that way. We've got to look at those cases holistically. Incarcerating somebody like that is really probably not going to do them very much good at all.
Yeah. Let's listen to a little bit more of what Mayor de Blasio had to say on this issue and the need to end solitary confinement in the city.
But we need to make changes immediately in how people who are incarcerated in our jail system are handled, and we need to make sure they are safe. So effective immediately, people with underlying medical conditions will not be subject to punitive segregation or solitary confinement. There already have been some prohibitions in place, for example, for serious mental illness or pregnancy. We're expanding the list. There's a list on your screen right now. Every medical condition you see on your screen would be a cause for a prohibition of any individual being put into solitary confinement. That's important. We're doing that literally. But we have to go farther. So let's take the next step. Let's end solitary confinement altogether.
Now, Judge Birmingham, in my opinion, this is a common sense approach to an issue where if you have a serious medical issue or an underlying medical issue, that we would not segregate you or isolate you in everyday life. I mean, especially now during COVID, we are seeing some of the serious repercussions of people not being able to leave their home, the isolation that they're feeling because of that. That's great, but it always breaks my heart that we have to lose someone to learn something. This appears to be something that should have maybe been on the books because it's so common sense in the past. But what do you make of this movement towards, okay, if you have a medical issue, that will disqualify you for solitary confinement?
Well, let me just say this. As an elected official in Texas, I wholeheartedly agree that we need a little bit more common sense in our laws, and that's one of the things that I'm trying to accomplish here, and I think we should all be doing that. It makes common sense, and we got to make sure that we keep the dignity of the individual intact as they make their way through the system, and I think that these common sense reforms that the mayor is talking about are well-deserved, and yes, probably a little too late to the ballgame, but man, I'm glad that we're at least getting them now.
Yeah. And Hunter, I always want to be clear, and I want to get your opinion on this in general about how this has really changed in reform and how we look at solitary confinement and the changes we're seeing that if you have a pre-existing condition or a medical issue that would affect you in solitary confinement, you won't be there. What are some of your thoughts as to how this situation played out, this death of a woman played out?
Well, the death was so unnecessary. This should never have occurred. It's very simple. When you have someone with a medical condition and they knew it, she was in a hospital, she was in Bellevue Hospital, brought back to the jail. They knew she had a medical problem. In this case, if I'm not mistaken, it was epilepsy. First of all, you don't put someone in solitary confinement for a minor, a minor crime that she had, that they claimed that she committed or that she did commit. You don't do that. You don't put someone in solitary confinement with a medical condition where that person can go into a seizure and cause harm to themselves or die. It's plain and simple. This needs reform. The mayor says he's doing that. I think it's a little slow to the uptake. This shouldn't have been there in the first place. We know this problem exists. They shouldn't be putting minor arrestees who can't make $500 bails in solitary confinement under any circumstances, especially ones with medical conditions.
Yeah, and I will say this: the arrest of this woman happened in April 2019. If she was simply arrested 8.5 months later in New York City, she would not have had bail. This would not have happened. She would have still had to come to court and appear in those appearances as any other defendant would have to be. But because of the bail laws, this hopefully won't happen, where we're seeing an individual incarcerated for $500 on a low-level charge, especially when it stems from trafficking or being trafficked. That fortunately doesn't happen in New York City, but of course there are those who are looking to change that. So the hope is that this reaffirms that we're going towards the right path in terms of how we're incarcerating, how we're keeping people in solitary confinement. Let's take a quick break and come back with more here at the Law and Crime Report.
Mr. President, what's your reaction to the indictment of your former campaign aide, Steve Bannon?
Well, I feel very badly. I haven't been dealing with him for a long period of time, as most of the people in this room know. He was involved in our campaign. He worked for Goldman Sachs. He worked for a lot of companies, but he was involved likewise in our campaign and for a small part of the administration very early on. I haven't been dealing with him at all. I know nothing about the project other than I didn't like, when I read about it, I didn't like it. I said, this is for government, this isn't for private people. And it sounded to me like showboating, and I think I let my opinion be very strongly stated at the time. I didn't like it. It was showboating and maybe looking for funds, but you'll have to see what happens. I think it's a very sad thing for Mr. Bannon. I think it's surprising, but this was something, as you know, just by reading social media and by reading whatever it is, and by speaking to Mike and all of them, I didn't like that project. I thought that was a project that was being done for showboating reasons. I don't know that he was in charge. I didn't know any of the other people either. But it's sad. It's very sad.
All right, so let's give a little context as to what President Trump is saying there. Brian Kolfage, Andrew Badalato, and Timothy Shea, as well as Steve Bannon, as he was talking about, have been indicted on charges of conspiracy to commit wire fraud and conspiracy to commit money laundering. Now, the program that he's speaking about was called We Build the Wall. And what they're saying is, or they being the federal government, is that hundreds of thousands of dollars donated to the online crowdfunding campaign were illegally used by those four defendants in a misappropriation of funds through that wire fraud, as I was talking about earlier, or at least the conspiracy to do so. Let's bring in our guests and talk more about this. Hunter, let's start with you. I mean, Steve Bannon was in the news about this. This came out in so many ways. We've heard about this Build a Wall that was attached to President Trump's campaign promises, and now we're hearing that hundreds of thousands of dollars were allegedly misappropriated. What did you make of it?
Well, first, I think they were saying in excess of $1 million was misappropriated, and maybe more than that. What's really what you have to look at here is there was a collection of a large sum of money, and the promise was all of the money was going to go to build the wall, whether you like it or you dislike it. That's what they promised when they got contributors to donate money. It was very clear. No one expected it to be used for personal reasons. No one expected it to be utilized for distribution among the four or the three people involved. And here, that's what happened. This is a classic case of fraud if those facts are true. What we know is they collected millions of dollars, maybe in excess of 20 or 25 million, and a chunk of it went into these people's pockets, according to the government. It is wrong, and it should never have happened.
Yeah. Now, Judge Birmingham, the prosecutors told the judge last week that they may be seeking a gag order because one of the defendants, Kolfage, supposedly had highly inflammatory language. That's the language that they use in describing it. That was on his social media, specifically on Facebook, where he was streaming live videos. Now, the judge said if the judge determines that the public statements by attorneys or the defendants threaten the court's ability to conduct a fair trial, a gag order may be in place. Talk to us about gag orders and how they may be used in a case like this.
Well, gag orders conflict with the First Amendment. Everybody has a right to free speech, but we also see that the fact-finding mission of a trial is of the utmost importance as well, especially when you're talking about cases as important as this. So if any of the statements are going to be made or are calculated to try to persuade jurors before the trial or to impugn the integrity of that fact-finding mission, well, then the judge needs to put a gag order in place, basically telling lawyers you're not allowed to talk about this case, do all your talking in the courtroom, try your case to the jurors to maintain the integrity of the process. And that's why I think, jury trials to me are so exciting, is because that's really the time in a case where you really get to see what all the evidence is in a particular trial, in a particular case.
Yeah. And in this case, I mean, oftentimes, Judge, let's throw this one to you again. in the federal government, when they prosecute, there is oftentimes a plethora of information. We're hearing search warrants executed for physical evidence, that being like hard drives. They went to the cloud. They got all this information. What kind of trial would you expect? And we're talking about conspiracy to commit wire fraud and just the volume, because a lot of people were donating to this, as Hunter pointed out, with the money that was funneled into this. What kind of trial would you expect if this does go to trial?
Probably one in three parts. The first one is going to be the solicitation. What did they say in order to get people to donate? The second part will be the collection of it. Where was the money stored? And then finally, the part's going to be the disbursement. How exactly was this money dispersed? Where's the wall, first of all? Where's this wall that they were going to build? And, then you start looking at the individual lifestyles after. How did they change? Did they start buying things that they weren't otherwise normally buying? How did their lifestyle change? So I think the trial will follow those three steps.
All right, Hunter, you're a trial attorney through and through. Talk to me about the strategies in a trial like this for either the prosecution or the defense. How are they going to kind of navigate this case?
Well, I think from the prosecution standpoint, it's fairly straightforward. Follow the money. You always follow the money. It's easy to see when the money came into these accounts. It's easy to track it through the time it's sitting in the accounts, and then it's easy to figure out where the money went at the end. And at least as the prosecution saying, the money went not directly into the pockets in many occasions. It was actually, according to the government, funneled through entities. They're going to have a hard time, the defendants, explaining why this money didn't go and build a wall when it went through different entities and ended up as personal expenditures. Yeah. So from that standpoint, it's a pretty straightforward prosecution of a wire fraud or a financial fraud.
Now, Hunter, I'm already thinking trial strategy. I'm thinking if I'm a defense attorney here, I've got to sever. I don't want my client being charged in this group. Do you think this could be a case where we see 4 defendants sever their cases and maybe start pointing fingers at each other, maybe taking plea deals, and maybe some snitching or some informants on one or the other?
I think this is a classic case for someone taking a plea, and there's nothing wrong with it. They know what they did if, in fact, these facts are true. Someone is going to crack, someone is going to come forward and say, give me the best deal now and get me out, and we'll provide evidence to support the convictions against the other people. This is exactly what I would expect in this case. The question is, which one?
Yeah, we'll wait and see. The trial date is set for May 24th of next year, 2021. So maybe we'll see that. And from now until then, I absolutely agree when it comes to that, Hunter. Someone's going to take a plea, and we're going to hear a great witness take the stand against someone. Who that will be, we just got to wait and see. Let's switch gears as we now talk about Ron Jeremy. Now, some may know Ron Jeremy as a pornographic actor in many films. Now he's being charged with not just one, but 17 different victims came forward on different sex charges. He is facing these charges that span from the somewhat minor sexual charges all the way up to the very, very serious ones. These allegations, he pled not guilty in June to allegations that he raped 3 women and sexually assaulted another in a separate attack, going back as far as 2014. On Monday, when he was arraigned, he was looking at just a few charges, but at that arraignment on Monday, 20 more additional rape and other sexual assault charges involving 12 more women, meaning he went from 5 alleged victims to 17 in a single day. The prosecutor added more on. Judge Birmingham, what do you make of these? I mean, the new ones that go back from 2014, but this looks like another Harvey Weinstein-esque case, another Ghislaine Maxwell type case where these allegations, the earliest one, are going back from 2004, and the number of alleged victims seem to keep growing by the day.
It's going to present some tremendous problems for the defense, because of the number of victims. If there's commonalities in the way that these crimes were committed, if there's commonalities in where they were committed, those types of things, the law disfavors, trying more than one crime at a time, basically. And so when you have a number of victims like this, then it just opens the door for the potential to have more than one crime tried in the same trial, which is usually never very good for the defense. So it'll be interesting to see how these cases develop and whether or not these extraneous crimes are going to be used against Mr. Jeremy.
Yeah, just a few other facts to throw out, Hunter, before I get your analysis. If convicted of all accounts, he could face up to 250 years in prison. He's currently in on bail, on bond, on $6.6 million. Doesn't seem like he's going anywhere anytime soon. And the range for the age of the victims go anywhere from 15 to 54 years, where a teen, or one of them, a teen was assaulted at a party that she attended in Santa Clara. I think, Hunter, as a trial attorney, it's going to be really come down to character evidence and also MO. I'm expecting that these women are probably going to testify to similar events of being either sexually assaulted or raped. What are your thoughts? All right. Judge, so we're going to take a quick second from Hunter. Judge, same thoughts. As we hear like the countless numbers, the similar charges, I don't know. Am I just, is it just that Harvey Weinstein is just picking up on my brain so much more because we just saw that? What do you think of the way this case might be tried, Your Honor?
Well, there's going to be the named victim in the trial, the named victim in the indictment, and the way these things usually play out is that you have evidence put forward about what happened, and then you use the extraneous conduct not to show that, well, he did it in other cases, therefore he did it in these cases, but basically, there's similar circumstances, there's similar ways. You said MO, modus operandi. If you have some unique characteristics that are created or are used to commit the crime that is indicted, well, then those other extraneous crimes can be used against him. And especially when you talk about sexual assault, usually what happens is they fight the identity. Well, I didn't do it. Okay, well, I did it, but it was consensual. Now, that's going to be tricky for him, especially when you start talking about with a 15 or an underage person. Consent doesn't really even matter. So prosecutor has a lot of power to see which case they're going to go through first. They'll probably make that decision based on what they think will allow them to get the most evidence in during that trial.
Yeah. Now, some of these charges go back pretty far, Your Honor. I know that in the past, in the Harvey Weinstein trial, for example, the statute of limitation issues came up. I think Hunter, actually, Hunter, let me go to you and field this question. Taking the entirety of this case, the allegations, the age of the victims, the potential for there to be some very damning character evidence against Ron Jeremy, how do you think this trial could play out?
Well, first of all, I think it's an interesting case in the sense that you have the defense making statements publicly already that he is a porn star. He's in the Guinness Book of World Records, I believe, for having been in so many. He would never, someone like him doesn't have to do this. This is an absurd defense. If they go into the courtroom with this, it falls flat. We're dealing with ages of 15 and up. If there's any type of trafficking claim alleged for those 15-year-olds, there is no statute of limitations. He is going to have to hear each one of these victims appear in court and lay the story out regarding the various assaults. And from what the prosecution has been saying, some of these are pretty egregious, outrageous situations, both in public and in private places. His trial is going to be an uphill battle for the defense.
Yes, and with 250 years of jail time on the line, because the assumption is, and it's a pretty safe assumption, if he was found guilty, these charges would be run consecutively rather than congruently. That's why that timeline spreads out so far. It's something the defense is really going to have to work hard for to try to sow any reasonable doubt into any of these cases. But we'll make sure to keep track of that as that case continues here at the Law and Crime Trial Network. But before that, we're going to take a quick break and come back to more here. So a New Jersey teen decided to have a Black Lives Matter protest in Englewood Cliffs, New Jersey, to have people come and talk about the disproportionate laws in the affordable housing that affected Black and brown people. You can see the teen there, Emily Gill, 18 years old. After forming that protest, she was faced with a bill of $2,500 for the overtime of the police department having to be present during that time. Now, it appears that that bill has been rescinded. The mayor said that someone in his group recommended that bill and he went forward with it. Then, upon consulting with his bureau attorney, they found there may be some issues with that bill, and that bill was rescinded pending the approval of the council. However, the argument that Ms. Gill and others are making is that this 20 to 30 people protest, where the police really didn't monitor it all that much, and there was no violence or real need for them to really interject, that bill was only rescinded once public opinion came out and this argument started that that bill should never have been there. Now, I'm joined again with Judge Birmingham as well as Hunter Shkolnik. Hunter, let's start with you. I read this, and the first thing I thought about is, I thought we were not allowed to abridge the rights of speech or peaceful assembly based on the laws of Congress, and that trickled down to municipalities. This sounds like a clear violation of the First Amendment, or at least a chilling effect thereof. What were your thoughts?
This is a prime example of utilizing a law to prevent someone from exercising their First Amendment right. This Black Lives Matter protest, which was small in comparison to ones we've seen across the country, what was really the idea of charging this young girl $2,500 or $2,600 for police presence just to exercise her First Amendment right is unconstitutional, and this should be stopped. Plain and simple.
Yeah. Now, the Democratic council members released a statement about the mayor's actions, saying, quote, after causing a national outcry against his tyrannical, blatantly unconstitutional, and deeply immoral behavior, the mayor is now apparently backing off his demand for the local teen activists to pay thousands of dollars for organizing a small and peaceful protest against racism. However, he has still refused to apologize, and our Bureau Council members are still exploring ways to hold the mayor accountable. Judge, what did you make of this asking an 18-year-old to foot the bill of such a protest in such a manner?
Well, I think when you use the word chilling effect is quite the perfect way to describe that. It's different. We were talking about the First Amendment rights of the lawyers in the other case, but this is totally different. And I think what you're going to see is that there have been a number of states across this country who have recently tried to, or said they were going to try to enact laws about criminalizing conduct and protests and things like that. And I think what we're going to see on the legal horizon, or what we do see on the legal horizon coming up for judges, is going to be how do we interpret these against the protection of the First Amendment, and which one's going to win out. So I actually do look forward to sort of researching issues just like this, and look forward to the upcoming debates about the strength of the First Amendment and what it means.
Yeah. And in part of the original letter, Hunter, the mayor had penned this argument on city stationery and defended his actions. He said, quote, we incurred expenses, which we often do when there's outside events coming through town. He also said, and I sent her a bill for the police overtime. We've seen this kind of being a trend where mayors will send overtime bills to citizens for the actions of officers. I've never really heard of this until like the last 2 or 3 years. What do you make of this growing trend that people are getting charged extra for civil services?
Well, first of all, this is not the circus coming to town or the carnival coming to town where you have to utilize the city services to provide safety to the community. These are young people. These are people. These are citizens exercising their rights under the Constitution. You don't charge them for the police presence. Plain and simple. This is more than a chilling effect. This is a way of just trampling on the rights of these people. And this young woman was doing what was right under the Constitution, and now they were trying to punish her to stop others from doing it. It's wrong.
Yeah, and just more facts about the protest. The understanding is that the protest merely lasted 90 minutes. I know also that Ms. Gill had said that the police presence was minimal at best because, again, as we're talking about a 90-minute protest of 20 to 30 people where officers were popping in and out, doing their job as they're supposed to, but now they're getting charged overtime Well, the question would be, why was there not an officer there during their regular tour duty? Why is it that citizens, when they exercise their own rights, they are going to get a bill after the fact? You don't get a bill for exercising your First Amendment right, or your Second Amendment right, or your Fourth Amendment right. Heck, you don't even get a bill if you exercise your Sixth Amendment right and you get a public defender. So that really doesn't make sense. But again, I want to thank our guests, Hunter and Judge Birmingham, for being with us. Always appreciate you guys coming on and lending your expertise. We'll be back with more, and we'll have more of a regular scheduled program after this. Have a good day, everyone.